Everyone, welcome back to the channel. My name is Shikha and I'm a legal intern at LEXIS and Company. I'm a law student from UPS Dehradun. In today's video, we will talk about the different types of writs that can be issued by the Supreme Court and the High Court. But before starting the video, there's a small disclaimer that this video does not solicit any kind of promotion or advertisement as per the guidelines of Bar Council of India, and the only purpose for which the video is made is educational purpose. So let's begin with the video now. Under Article 32 of the Constitution of India, the Supreme Court have power to issue directives, order or writs in nature of habeas corpus, mandamus, certiorari, prohibition and quo warranto for enforcing the fundamental rights of the citizens of the country. Similarly, in Article 226 of the Constitution of India, the same power is given to the high courts in the country. So the citizens can approach to the High Court and the Supreme Court in case their fundamental right or any legal right is violated, and the courts can enforce them by issuing such directions, order or writs which is appropriate. The power granted to the High Court under Article 226 can be said to be broader than the power granted to the Supreme Court under Article 32, because in Article 32 it only states for enforcement of the fundamental rights, but in the Article 226 it states both fundamental rights and other legal rights. So in this sense, the Article 226 have a broader meaning than Article 32. Now let's discuss the 5 types of writs one by one. The first one is the habeas corpus. It is a Latin term which means to have the body. In this, when a person is unlawfully detained by other person, then this writ can come to the recourse of that person. He can, by his friends or family or anyone else, approach the court for stating that he have been unlawfully detained by a person or any public authority. The person then can order such public authority or private individual to appear before the court and state the reason why he had unlawfully detained such person. And if the reason is not legal, then he may be rescued and he may be taken out from that detention which he was illegally put into by the person. Here the important thing to remember is that the habeas corpus is the only writ which can be issued against a private individual, unlike the other writs which can not be issued to the private individual. Next writ is mandamus. This is also a Latin term which means we command. Here the Supreme Court or the High Court issues an order to the public authority to do something or restrain them from doing something. Here there is a public duty upon upon any public authority, and the court either says him to do that to do a thing which is lawfully to be done by that person, or abstain him from doing such things which are not in the power for him to exercise. The legal duty here is either created by the Constitution or by any statute or by the common law, which may not be statutory always. This writ is applied to constitutional, statutory and non-statutory authorities as well. Mandamus can be issued to the government authority when they are not exercising the power which are to be exercised by them. Mandamus can be not issued unless the applicant have a right which can be enforceable. The next writ is the writ of certiorari. This is also Latin term which means to certify. In this, the Supreme Court and the High Court orders the inferior courts or the quasi-judicial body to transmit the documents related to a proceeding before them for judicial scrutiny of the documents and the proceeding, If the proceeding is found to be illegal or unlawful, then the proceeding is also quashed by the Supreme Court or the High Court. Here, the important thing to note is that the body exercising the body here must have a legal authority to determine the rights of one person and have to perform his function judicially. So the certiorari writ can be issued in cases like when there is excess of jurisdiction exercised by any tribunal or any court, or there is any want of jurisdiction, or in cases where there is violation of any natural justice. The next writ is prohibition, which means to prohibit. In this case also, the Supreme Court or the High Court issues an order to the inferior courts or the tribunals to stop a proceeding which is laid before them, because it is in excess of jurisdiction, or the court have no jurisdiction to try such proceeding. Also, in cases of violation of natural justice, the writ of prohibition can be issued. The difference between the writ of certiorari and writ of prohibition is that in case of prohibition, the proceeding is being continued in the court, while in case of certiorari, the proceeding have already been closed and the decision have been made by the court. The last kind of writ is quo warranto, which means by what authority. In this writ, the Supreme Court and the High Court orders a person holding a public office to appear before the court and to show that why he must be allowed to continue to hold that office. So, in case when the person do not have authority to continue that office, he is removed from such office. This may be done when he is holding an office unlawfully or unlawfully, etc. So these were the 5 kinds of writ which can be issued by the Supreme Court or the High Court under the Constitution, under the Article 32 and the 226 of the Constitution of India. These powers are granted on the courts basically to enforce the fundamental right of the citizen of India and to guarantee them with justice. So that's it for today's video. If you have any doubt or if you have any feedback, please write it down in the comment section below. Thank you so much.